welcome to our commercial seminar. My name is Jenny Ching. I am your 2021 Education Community Co-Chair. Today, we have Ms. Juliana Tu from Viva Escrow to present bulk sale transactions. An escrow officer since 1977, Juliana of Viva Escrow is one of the first escrow officers of Chinese descent in the state of California. Whether paying it forward or giving it back, Juliana is committed to making a difference in her escrow industry. This dedication led to many decades of serving her peers in the industry, culminating as president of the California Escrow Association in 2019. For many years, Juliana served on the Escrow Advisory Committee of California's Department of Financial Protection and Innovation, the regulatory agency for the independent escrow companies. She also serves on the Los Angeles County Assessors Advisory Council. In 2012, she published her book, The Art of Escrow. In 2020, during the pandemic, she established her YouTube channel, Think Escrow, in which she continuously adds new content to educate the public on the escrow process. For more of her personal background, please visit her at www.juliana2.com. For Juliana, her motto has always been to pay it forward. Knowledge and experience means nothing if it is not used to benefit others or if not passed on to the new generation of escrow officers. A friendly reminder before we begin, all participants will be muted during the meeting, so please use the chat box for questions and the speaker will answer them during the Q&A session. This meeting is being recorded and will be available on our YouTube channel. So without further ado, let's welcome Juliana.
Hi, everybody. Was that me? Is it okay? Yeah, we're okay. Okay, good. So thank you for having me on. I tell my escrow peers that I am the last president of the California Escrow Association pre-pandemic. Everybody else is during pandemic. So anyway, are we there yet? Or is it hurry up and wait? These are the most common gripes in a bulk sale transaction. It's like little kids on a road trip, except we aren't kids. And in some really bad cases, it can be considered a road trip through hell, especially one that involves additional issues like ABC license transfers and now the PPP, EIDL loan payoffs and so forth. So I have 1 hour now to talk to you about the trials, tribulations, and drama of bulk sales transactions during the pandemic. In a good day, bulk sales are never as easy for escrow officers to handle as real property sales. And that is because they are, one, not as common, two, often are for sale by owners transactions and have no real estate brokers like yourselves involved. There is also three, no title insurance to back us up and advise us if something or a document is right or wrong. And number four, there are many outside players and factors that are critically important to the transaction for which we cannot do without. Now, I gave a webinar on the bulk sale transaction in November of 2020, but I will take a couple of minutes right now for those of you who did not attend that session so that I can bring everyone up to speed. Selling businesses and their assets, what we call personal property, is quite different from selling real property. Personal property can be tangible, like fixtures, equipment, inventory, things that can be added or subtracted during the course of the transaction. And it also includes intangibles like trade name or goodwill. Real property, on the other hand, is land and structures or whatever is fixed to the ground and cannot be moved. So if you walk down a commercial street Every piece of property that you see on the street can be sold. Also, every store you see on the street can be sold. Donut shops, restaurants, convenience stores, liquor stores, car washes, car dealerships, even service businesses like dental offices, massage parlors. When they are sold, all these are what we call bulk sales or business opportunity sales. I will use these two terms interchangeably throughout this presentation. And then, of course, we have a combination, which is the real property plus the business sales. So we are going to talk a little bit about the differences between the two. The most important difference between these two types of transaction are as follows. In real property sales, we work in conjunction with a title company who will insure against all the liens and encumbrances that do not belong to the incoming buyer. That is the transaction's safety net. In real property, in business opportunity sales, there is no title company that provides title insurance. So there's no safety net. It's all dependent on how savvy and knowledgeable the escrow officer is. So not all escrow officers handle bulk sales. For some, there is just too much risk and it is too different from what they know and practice in real property sales. Here are some of the other differences. The handling of a bulk sale is defined specifically in California law through the Uniform Commercial Code, the UCC, and or the Business and Professions Code, the BNP. In a real property transaction, you can have a 5 or a 10-day escrow as long as all the conditions are in, right? But in a bulk sale, there is a 12 business day time period for a wait before closing. And that's according to the UCC code. In a real property, we have a prelim. In a bulk sale, there's no prelim, but instead we are required to do what we call a UCC search of the business name and the seller's name in the Secretary of State and at the county recorder's office. So no grant deed is used, but we use a bill of sale to show transfer of ownership. And this document is not recorded at the county recorder's office. In a real property, normally, whoever's on the last recorded title ownership document is the seller. In a bulk sale, there is nothing that is recorded. So we have to rely on various other public documents to make the determination. For instance, the business license, the ABC license, the CDTFA seller's permit. Unfortunately, this can cause quite a bit of confusion, as I will cover later. Landlord approval. This is very important and has been the cause of cancellation of bulk escrows when the landlord feels that the new tenant may not have the financial background to keep the business going. So they disapprove of the buyer, and that your whole transaction falls through. Clients rarely question why an escrow transaction for a real property is needed, but they often wonder why an escrow is needed to transfer a business opportunity. And here are the reasons. Probably the most important reason is that the law requires the seller to give their creditors and vendors notification of the sale so that they can submit their claims for payment. If these creditors are not notified properly, they can and they will attach the unpaid claims to the new buyer that is taking over. So we have to publish the sale of the business in the community newspaper for a period of 12 business days before that sale can be finalized. This is the prescribed time for creditors and vendors to submit their claims to escrow. Another important reason, we need to make sure the buyer gets released of all sellers' government tax debts, employee taxes to the Franchise Tax Board, the FTB, employee unemployment taxes to the Employment Development Department, the EDD, and the sales tax that has to be paid to the California Department of Tax and Fee Administration, the CDTFA. This is the sales tax for the sale of goods. So we will be looking for certificates of release of the buyer so that these agencies cannot come back and claim any unpaid seller's taxes from the buyer. And finally, an escrow is needed if there's any sort of a liquor license that is issued by the Department of Alcohol and Beverage Control, ABC, that needs to be transferred. Today, I am going to talk about the problems that we have seen, not only throughout the pandemic of 19 months and counting, but also in general, so that we can ask you to help us avoid these problems in the future. So let me share our trials and tribulations. I'm going to break down the problems into 5 concerning topics. Time,
Sorry,
incorrect.
Juliana. Sorry, Juliana. Are you supposed to share your screen? You have a PowerPoint?
Yes.
Okay, you want to share it?
You mean I have gone through all this without sharing?
I figured that would maybe the idea. Go ahead, please share.
All right. I am so sorry about that. Can you all see
Yes,
this?
yes, we
Okay,
can see it.
wonderful. And I am so sorry about that. I will go back and start this portion again. So I'm going to break down the problems into 5 most concerning topics: time, incorrect client information, ABC license transfers, those pandemic government loans, and real estate plus business purchases. Time. Time is of the essence. Sometimes this is just another phrase, especially during this time period. Our clients may say, go, 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 hurry, hurry, we want to close. But no matter how fast we go, those outside players that I talked about that we have to deal with have a concept of time that is quite different from ours. Time is not our friend because working from home during the pandemic means delays. Up to now, a lot of the government agency staff are still working from home, whether it is the ABC, EDD, CDTFA, or the FTB. This means that our requests are now handled via email or online, and the response back is much slower. Other county agencies are now barely open to the public. Did you know that the county recorder's office just opened up October 1st? But they don't allow you to go in and visit them unless an appointment is made. Now, what is the first thing that has to happen to start the bulk process? We have to record the notice to creditors. We have to record the notice of intent to transfer liquor license. It used to be that the search and publication companies would just walk into the recorder's office to get the recording done. Now, no more. Either you make an appointment to walk in or you sign up with a vendor to do this electronically. Sending the documents in the mail means that you can expect a recording within 3 weeks. So if we as an escrow company needed to record something, what we do, for instance, like a tax lien release, what we do now is we find a title company who is willing to record our document as an accommodation. And we say, please, please. So during the pandemic, we have done the same thing for the notice to creditors and the notice of intent. We have sent them to record as an accommodation to the title companies to save time. And then we ask the publication company to get the certified copies from the recorder's office once they have been recorded. In the matter of unsecured property taxes or liens, requests for the amounts due from the county assessor's office were also delayed because the staff were not in the office. But the biggest problem are the other government agencies, especially ABC. For ABC, we understand that in many district offices, the licensed investigator may only go into the office maybe once a week. So if they are working from home and they are organizationally challenged, we may have a problem getting them to check off each individual item that is needed on the license transfer application. And the same goes for the client applicant. Time is also an issue. There's a whole slew of documents that needs the client to provide when they're trying to purchase a license. Even if they hired a third-party license transfer coordinator to help them, some things require the client themselves to provide or perform. I have one transaction which opened up in October of 2020. It has been 1 year and the license just transferred. 10 months into the transaction, ABC told the license coordinator that fingerprints from the spouse of one of the LLC officers was also needed. So the spouse lived out of state. It took a whole month for the spouse to get the fingerprints done in her state. And when I checked back, the license coordinator said, yes, they got the fingerprints. It was done, but it was submitted to the DOJ and the FBI, and they were rejected because the fingerprints were not legible. So a new form had to be sent out for new fingerprints to this spouse. So all parties, the clients, the license coordinator, and the government agencies all have to be cognizant of the time element and do their best to expedite everything. Then we have incorrect client information. Hold on a second, let me move the file over. This is the source of many headaches for us. When the escrow officer starts out the process, we have questions we ask of the seller client, and we ask for copies of their licenses. If you as an agent are putting together a bulk sale transaction, keep in mind what we go through and get answers for the questions that we are going to ask before the transaction is opened. It will help your escrow officer open up the transaction much more expeditiously. Getting a copy of the licenses from the government agencies like the city, the county, the CDTFA, and ABC is absolutely essential. Remember, we need to determine who the actual seller is and the correct names. Unlike real property, incorrect client information from the buyer side causes a lot of confusion and trouble in a business escrow. It is not as easily corrected. It's not just do an amendment, change the buyer, and then just get the grant deed to be redone. If the buyer's name changes after documents are drawn in a bulk sale, it's not just re-signing and re-notarizing the bill of sale. It also requires the republishing of the notice to creditors, republishing of the notice of intent, resubmission of the certificate request to the EDD, CDTFA, and FTB, because those certificates that they issue at the very end should reflect the correct buyer's names. Does the seller have a corporation or officers that is matched, that is listed? Are they listed? Are they the same as those that are filed at the Secretary of State? What does the city and county business license say? Does it match what is listed on the ABC license? Does it match what is listed on the CDTFA license? What about the EDD account? If they don't match, something has to be done and corrected so that it all matches. We have to publish under the correct name. The ABC requires the right officers to sign off on the license transfer, and the CDTFA and EDD have to match our seller to their records, because if they don't match, they cannot give us a release. We have one case in which all three did not match. The seller was XYZ Corporation. John and James said that they were the corporate officers, but the records at the Secretary of State did not match that. The ABC license said that the license was under William as an individual. Apparently, he was a brother who applied for the license way back when, and he never changed it. The CDTFA and EDD accounts were issued to John and James under their individual names. It was such a mess. So to open escrow correctly for this transaction, this is what the seller had to do. They had to file the correct corporate officer information with the Secretary of State. They had to notify CDTFA and EDD to change their accounts to the corporation. And they had to do a transfer of the ABC license from William to the corporation. Now, this transfer process involved much of the same background and fingerprint check that the buyer would have had to go through. So all these things had to be done before we could actually open up escrow correctly. From time to time, we get sellers whose corporate status was suspended with the Secretary of State. Well, in order to do business in the state of California, and selling a business is doing business, you have to be registered. You have to be a valid entity to do business here. Are you a corporation registered in another state? If you are, then you will also have to be registered here in California. So get the attorneys to file the registration before escrow is actually open. No matter if you are the seller or the buyer, we need your corporate operating agreement if you are an LLC, and bylaws if you are a corporation. We need to see who are the corporate officers who should be acting and signing for the corporation. In one of our transactions, one of our corporate sellers had an officer whose name appeared as the corporate secretary on the Secretary of State site. So we needed his signature on all the paperwork. But apparently, he was a minority shareholder and he did not want to sell. We advised the seller that he had to go and figure out what to do with this minority shareholder because he was a corporate officer. The main officer and this minority shareholder had to come to an agreement, and the minority interest was given up, and a change in the corporate officers filed with the Secretary of State. ABC license transfers. You need a little drama in your life? Well, here you go. A small restaurant was owned by a corporation. The seller was the president, and this was verified in our search with the Secretary of State. The seller went ahead and signed the ABC 211-A form. Now, this form is important because it starts the license transfer procedure. It just says the seller is willing to transfer the license to the buyer. Now, 2 weeks after this form was turned into ABC, it was returned to us with a notation that in their files, in ABC's files, another person was the president. And so this other person had to sign also. When I told my seller, she said that 7 years ago, this person was bought out of the company, but they didn't give any notification to ABC. However, my seller said, it's no problem. I'm on good terms with this person. She was going to go find him so that the form could be signed. Mind you, the 211A form can be signed in two ways. Either you sign and have your signature notarized and then turn it into ABC, or you can sign it in the ABC office itself, and you have to provide them with your proper identification. So here's where the drama came in. Mr. Kim, the original president, had changed his Korean name to an Americanized name when he became naturalized years ago. He no longer had any identification showing his Korean name. He could not provide a picture proof either to a notary public or to the ABC investigator. After 2 weeks of running around trying to find a way out of this mess, our actual seller did find someone who could notarize, and the form was signed by Mr. Kim and then notarized and sent in. Just this initial process of signing off on the license to begin the transfer, which should really have only taken a few days, took an extra month. This is a seller, but incorrect information from the buyer also creates a whole slew of drama and stress. And this is why we insist that a buyer make his decision on the purchase right up front. Will he buy this as an individual or as a corporate entity? If a corporate entity is used, has everything been filed? And does he have all the corporate documents? Any delays in setting up the corporate entity will delay the transaction. If ABC is involved and the buyers change, all the parties have to re-sign the notice of intent. I'm talking about the buyer and the seller. They all have to re-sign the notice of intent because that will have to be re-recorded so that a county recorder's certified copy can be provided to the ABC. Of course, all the ABC application paperwork has to be changed, and possibly other paperwork and fingerprints will be needed, like from a spouse. ABC will also need to review the corporate documents. And when this change happens close to the closing date, yep, there is a little bit of drama. I had a transaction that opened in the middle of February with two individuals as buyers. In the middle of March, the two individuals decided to form an LLC. When we were trying to close escrow by the end of April, the LLC finally got their corporate documents together. And lo and behold, after review, ABC found out that one of the persons listed on the application was not actually a manager of the LLC. So we had to change the escrow again to show one manager signing only. As mentioned previously, every time there is a change, the notice of intent has to be re-recorded and a certified copy provided to ABC. 1 week to get the recording done as an accommodation with a title company, and then another 2 weeks to get a certified copy from the county recorder for the ABC. For this transaction, we had 3 changes. So it was a 9-week loss of time just to get the buyer's name corrected. Of course, there were other things that were happening during the same time: the seller's SBA loan, the buyer's refinance loan for the closing funds. This transaction that opened in February and was scheduled to close at the end of April did not close until the beginning of August. So time, incorrect client information, and ABC license transfers, these are all problems and more problems. So now let's talk about those pesky pandemic loans. I call them pesky because all they do is cause trouble and annoyance for us. I'm talking about the PPP, the Paycheck Protection Program, and the EIDL, the Economic Injury Disaster Loan. Both of these types of government loans are handled by the SBA and are the government's response to help with losses sustained by businesses due to the pandemic. It's all great on the business side. When you're selling the business, however, it becomes tough. The PPP loan is handled through a bank of the business owner's choice, and the EIDL loan is actually given by FEMA, but handled directly with the SBA. Now, our escrow instructions have been revised to add that the seller will provide the buyer and the escrow with information regarding either of these two loans so that the payoff can be made. We require the sellers to sign under penalty of perjury that there are no such loans or that they have been disclosed. The headache rests on the PPP, Paycheck Protection Program. It does not have to be paid back and can be forgiven as long as the business owner submits the proper documentation needed to show that he has used the loan for the payroll. Unfortunately, this loan has no collateral filings, so there's nothing that we see on the UCC search that will point to a PPP loan against the business. We must rely on the seller's honesty and integrity to let us know that the loan has been forgiven. If there is or there was a loan, we will ask for a letter from his bank that the forgiveness of this loan has been approved. And what happens if the PPP loan is not totally forgiven or the process has not been completed and escrow has to close? Well, the bank handling the loan may require sufficient funds to be set aside in escrow or to be given to the bank, deposited with the bank, pending finalization of the forgiveness process. This is something that the escrow officer has to discuss with the seller and his banker and find out what their requirements are going to be. Around September of 2020, I closed a small restaurant transaction. 2 weeks after closing, the buyer received a letter at the business addressed to the seller from the SBA, which talked about the PPP loan. Now, this was my first encounter with this loan. The buyer was so upset that we did not take care of it. But as I told the buyer, unless the seller had informed us, there was no way we could have known. There is a website that lists all the people who have gotten the loan, but it only lists those loans over a certain amount. This one that the seller had gotten was a very small one, but nevertheless, the buyer would have been stuck with it if it was not paid off. So understandably, the buyer remained very upset and distrustful of this seller. Now, there were 2 rounds of the PPP loan. One was in April to August of 2020, and the other one was January to July of 2021. If I am going to be doing a transaction now, hopefully the forgiveness for the first round has already been issued, and I don't have to worry about trying to get a forgiveness letter. And hopefully the business owner had no need for a second round. But if there was a second round that he got, that forgiveness may still be in the process. So we have to watch for that. The EIDL loan, on the other hand, is an SBA loan secured on the assets of the business, and payments are required. If the loan filing is over $25,000, then a UCC financing statement will be filed to the business, and it will be found when a UCC search report was ordered. The payoff of this loan is like any regular payoff, complete with a payoff statement and a requirement for a release or a UCC termination. The only difference is that getting in touch with the SBA to get us this loan payoff could be time consuming. First of all, SBA does not talk to anyone but the buyer. So unless the borrower, unless the specific instructions are given by the borrower that allows SBA to talk to escrow, they're not going to talk to escrow. So the best way we found out was to insert ourselves into the conversation by getting escrow, the SBA, and the seller on a conference call and get the authorization. Isn't that crazy? I was asked to open a transaction on a restaurant around July of 2021. The buyer wanted to rush the closing, but the restaurant had a liquor license. And I told them it would take at least 90 days or more to get the license transferred and escrow closed. The buyer couldn't wait. They wanted to apply for the PPP loan before the second round of program ended. Now, if I understand this correctly, the loan is to help businesses keep the payroll going so that people would not be laid off and the business could survive. So how was this going to work for a business that was just being bought and had no payroll data of its own? Well, needless to say, the buyer did not like my answer, so that I could not close without the liquor license transferred. So I didn't have to deal with the transaction. And maybe it was a good thing because that would have been a pretty stressful one. Now, I did open a pizza fast food transaction and it was smooth all the way until I got to the UCC search report. On it was a loan in favor of the SBA. Obviously, looking at that SBA loan, I knew it was an EIDL loan. So I presented the report to the seller and advised him that the loan had to be paid off. The whole transaction came to a stop. The EIDL loan that he took out was for triple the value of the restaurant sales price. Now, this seller did not realize that this loan was going to be filed against the business. And he said, hey, this is cheap money, minimal interest. Why do I want to pay it off? Besides, he said, I got it for the corporation and not the business. Well, the corporation name and the business name were both the same. And the filing mentioned it was against the assets of the business, including the fixtures and equipment and so forth. He would have had to pay it off or the buyer would be burdened with it. So that was the end of that transaction. On the other hand, I did have another transaction in which the seller had an EIDL loan that he was not going to pay off. Instead, he wanted to transfer this loan to his other ongoing business in another state, and SBA agreed to it. It took a few months, but they signed the necessary paperwork. And after much follow-up from me, the SBA contact person got their legal department to give me a UCC termination on our restaurant. See, they don't remember that they have to terminate it on my restaurant, and then they can put it on the other restaurant. Unfortunately, my pizza seller had no other business that he could move that loan to, so he would have had to pay it off. Real property plus business opportunity. Double trouble. Here are some of the questions that we ask. What is the breakdown of the sales price for each? Are the buyers and the sellers for each transaction the same, or are they different entities? Do we need to open 2 transactions? It is preferable, by the way. And if we do open 2 transactions, hopefully it will state that they will close concurrently. Is the buyer getting a loan? Is it on both transactions? Is there a liquor license? in the business transaction? And what are the other conditions that are special to these transactions? Stress comes when you have a real property purchase, which has to close concurrently with the purchase of the business that is on the property. The business has a hard liquor license. The buyer is getting an SBA loan to cover both purchases. And the buyer is using the real property as part of his 1031 tax deferred exchange. What doesn't kill you will make you stronger. And this is my final story for today. Each transaction in itself was not difficult, but circumstances conspired to make it difficult. And so it provided for an educational lesson to be taught today. Although both transactions had the same seller and the same buyer entity, and they could have been opened as one transaction, I elected at the opening of escrow to do it as two separate transactions because I have found that you just never know what the future holds, right? So separating them is best, just in case. Both transactions had to close concurrently, and of course, this verbiage was in there. The business was a mini market, and the liquor license was an off-site hard liquor license. So I felt that this qualification process might be a little longer. I did advise the buyer and seller of the 90 days minimum to get the license transferred. The buyer was getting one SBA loan to cover both purchases. And it seemed like the lender understood the process of what happens in a bulk sale with a liquor license. So far, so good. We were waiting for the SBA lender, and the SBA lender was waiting for the buyer to complete the license application so that the license could transfer. 4.5 months into the escrows, not only had the license not been transferred yet, the buyer calls up and advises me that he has to close escrow within the next 15 days because the real property, which was designated as part of his upleg on his 1031 exchange for $1 million, it was coming up. His 180 days was almost due. He had only 2 more weeks to close, or his exchange for $1 million would have been invalidated. Oh my goodness. Just shoot me and put me out of my misery. Now it became a mad scramble to figure out what to do. So here are the issues again. The real property had to close for the exchange, but it is 1, concurrent with the closing of the business transaction. 2, the business could not close without getting the authorization from ABC. And 3, the buyer's 1 SBA loan had to be secured on both the real property and the business at the same time. So it's a good thing that I opened to escrow. So I could close the real property once the parties eliminated the concurrent condition. After much negotiation, the SBA lender agreed to fund only the loan on the real property, but they had the caveat that everything had to be ready to go for the bulk sale closing. And that closing was only going to be subject to the receipt from ABC of the authorization to close. Okay. But I told this lender I was not willing to stick out my neck and request the authorization if I did not get an unconditional guarantee from the lender that the business loan would fund immediately upon the receipt of the ABC authorization to close. Can you imagine? The ABC tells me that the license has transferred, and then suddenly the lender would tell me, oh no, I'm sorry, I can't fund this loan. That was not going to happen. So chicken meets egg, egg meets chicken. After much discussion, the lender agreed to give me the guarantee letter. The final condition was that the seller and the buyer had to work out an agreement for after closing of the real property, because then the seller would now become the tenant and have to pay rent to the buyer, who would then be the landlord. Docs were drawn, all paperwork in both escrows were completed. The exchange company wired all the funds to close the real estate. The lender funded the loan on the real property, and the buyer deposited his down payment on the business escrow. The day we closed escrow on the real property, the lender gave me the unconditional guarantee letter that they were committed to fund the business loan. And with that letter, I overnighted the request for the license transfer to ABC. Meanwhile, outside of escrow, buyer and seller signed a seller leaseback agreement. Lease payments were going to start 1 month after closing of the real property, and the rent would be minimal. All's well that ends well. The business transaction closed about 3 weeks after the real property. It took them 3 weeks for ABC to transfer the license. The hardest part of these two transactions was that no one, not the buyer, the seller, the real estate agents, the lender, or the loan broker, really understood the process and issues involved in a business opportunity sale that had an ABC license. I had to write numerous emails and answered so many phone calls to explain the process again and again and advise them on what I could do and what I could not do. They didn't understand the constraints that we had, and that time was not really something that we could control. What a crazy industry this can be. So here we are, the trials, the tribulations of handling bulk sales at any time, but particularly through the pandemic years. Time, incorrect client information, ABC license transfers, and the brand new matter of pandemic loans. They have surely created a lot of drama in our lives. Now, if you have stories to add or questions to ask, I think we have a few minutes to give you the floor. By the way, my contact information is on the last slide. Thank you very much. I am sorry that I didn't have my slide share up. I thought I did, so oh well. Anyway, take it away, Jenny.
Okay, I think we have one question from Frederick. Juliana, what would happen if a vendor asks for a credit recognition that the seller didn't want to recognize?
If a vendor asks for a credit recognition that the, I'm sorry, that the seller would not
didn't want to recognize.
When we send out the publication, the vendors will have 12 days to send us what we call a claim letter. With the claim letter, we have to respond right away to the vendor saying, hey, we got your claim letter. We're going to send it to the seller to approve. If the seller gets that and say, I do not agree to this claim letter, then when we close escrow, we have to tell the vendor and say, hey, we're going to close escrow. The seller did not approve your claim. So what we're going to have to do is we're going to have to hold 125% of that claim of yours in escrow, and you're going to have to fight it out with the seller outside of escrow. That's all we can do. If within the 25 days, I think they have 25 days to fight it out. If they don't get to a resolution, I return the money back to the seller. That's what happens when you have a vendor claim that is not recognized by the seller. They have the right to fight it out with the seller, and I have to hold the money, at least 125% of it. Anything else?
Got it. I think that's the only question so far. Any other
Okay.
questions, please type it in the chat box. Okay.
Well, it's always a pleasure to talk to you all. If you have any questions and you don't have time, you can feel free to forward me your questions to my Juliana T at Viva Escrow email. That's my personal email, not my business email, but my personal email, and I will do my best to answer all your questions. And of course, check me out on my little Ink Escrow YouTube channel. I work hard at that to give you some information. Okay.
I think there's one comment, not really a question.
Okay.
Juliana, I like the examples you gave to illustrate the challenges you were confronted with. These are a lot of moving pieces in bulk sales. I'm sure some fell out of lack of cooperation from either parties. You explained the issues well. Thank you for sharing with us.
You are very welcome. And yes, it's a little different from real property. So there's a lot of things that are not really changeable unless it's at the beginning. So a bulk sale is always quite different. And you should always ask your escrow officer what they need before you go ahead and open up a bulk sale escrow with them. And especially make sure that your buyer is aware, or your seller, but mostly your buyer is aware of what is going on. Please do not expect the bulk sale to close immediately. And especially if there's a liquor license, like I said, it takes a long time for it to close.
One more question from D. Lee. The seller is a corporation and the buyer is the secretary of the seller. Can he sign for both the seller and buyer?
Well, in a corporation, we usually require 2 signatures and a corporate resolution. So if the secretary is signing for, I'm sorry, what was the question? The seller
the seller is a corporation and the buyer is the secretary of the seller.
Oh.
Can he sign for both seller and buyer?
So you've got a corporation, seller, and a buyer, and the buyer is signing as a corporate seller. You know what? It's always good to have an arm's length transaction. So if you have a seller corporation, have the seller president or so forth sign for the corporation. Don't have the buyer sign for that corporation. Because it looks kind of strange and it's not arm's length. I would recommend highly that the seller find another corporate officer to sign. And then we should really get 2 corporate officers for any signature. Anything else?
I think Dilly has a comment. The president is out of the country.
Oh, yes. Well, that is a little problem. In a corporation, he cannot give a power of attorney to another officer, but what he could do is this corporation could try to do a corporate resolution and designate somebody else to sign on behalf of the corporation, not as a power of attorney, but an actual corporate resolution, and have this president sign that resolution and designate somebody else who is in the US to help.
Thank you, Pauline. I was saying thank you, Juliana, for this informative presentation.
You're welcome.
Yeah, Pauline, do you have anything else to add?
Well, I just feel exciting. Finally, we see you, Juliana, so long time, right? And
yeah.
It's really wonderful. We got a lot of information today and valuable information, especially we know you're the expert for this category. So everyone need to contact Juliana for further question and mingle together soon, right? And on behalf of West and Gilbert Valley Realtors, we really appreciate and would like to thank Miss Juliana too, Viva Escrow, to give us so wonderful and so wonderful and so informative presentation today. We look forward to seeing you in our auditorium pretty soon. And thank you, thank you. And a quick reminder for our next week, we have 3 classes, Tuesday, October 19, 11 o'clock. You will know what is the difference from home warranty and home insurance. And Wednesday, don't miss out. Tony Watson gonna to give us a beautiful presentation for unpacking President Biden's Green Book. Don't miss out this one. And Friday, we have an attorney come to talk about ADA compliance and disability access claims. So many informative information will be coming up in our education classes. Check in wsgvar.com, choose the education schedule to learn together. Thank you again, Juliana, Jenny, Fang, and all of you joined today's webinar. We love you and want to see you together soon.
Thank you. Appreciate it.